We also face the challenge of the Supreme Court in Doe versus Reed. This Washington state case centered on whether the names of those who signed petitions to allow a vote on the registered domestic partnership law could keep their identities secret because of a claimed fear of gay harassers. Now, you laugh, you wait and see. In court briefs, those seeking to put our rights on the ballot and take protections away from us accused the lesbian and gay community of subjecting them to a systematic and coordinated, quote, intimidation campaign. They cited a veritable Niagara Falls of supposed incidents from California and Washington and elsewhere in support. Just one problem. It's a vile slander. In our brief with the other LGBT legal organizations, we, and GLAAD in particular, went after the facts. We examined every single incident of alleged harassment they cited nationwide. And we put it all on a chart. And we cited it in the brief, and we put it on GLAAD's website. And it shows, for starters, that the claim in Washington was utterly empty. There was not one incident of retaliation for signing a petition. We also wanted the justices to see for themselves the facts and whether there is any reality to the claim that the gay Goliaths are oppressing the traditionalist Davids. Now, I am not saying that nothing happened. After all, at this point, the ballot process has been used against gay people more than any other minority group, ever. Violence against gay people spikes during campaigns. People have some feelings about that. However, the few and truly serious claims came from public leaders of campaigns, particularly in California. They claimed death threats, fears of physical harm to self and family, and vandalism. Again, looking at the data, we found there was no basis for claiming that such incidents, even if true, were common, much less part of any kind of coordinated campaign. And those few claims attracted extensive media attention, precisely because they were so exotic, unlike the more humdrum violence and threats against LGBT people. Other than that, we found isolated incidents that, again, were repeated over and over and over. So take the oft-cited one involving a woman named Phyllis Burgess, who claims she was shoved at an anti-Prop 8 rally in Palm Springs and had her styrofoam cross broken. What we found was that Ms. Burgess appears to have deliberately staged the incident for media attention. She frequently protested at gay events, had told officials she was attending this rally, and appears from recorded tapes to have shoved her way to the front of the crowd with her cross in an attempt to get on camera. In barreling through the crowd, she knocked a disabled man to the ground before others in the crowd pushed her back in response. There you have it, the gay community targeting Proposition 8 supporters for violence. Now, most of the harassment campaign, so-called, boiled down to issues about yard signs and bumper stickers, or hurt feelings, like the country club member who complained in federal court that as a result of his Prop 8 yard sign, quote, "The openly gay members of the country club used to greet me warmly. Now they give me looks of disdain and do not greet me as I pass." Really, that's harassment. You're voting to take away my rights, and I'm supposed to give you a hug. So the Supreme Court thankfully ruled 8-1 that there is no general right to anonymity for petition signers. And perhaps most sweetly, Justice Scalia stated there are already laws forbidding threats and intimidation, but harsh criticism is a price our people have been willing to pay for self-governance. And hiding yourself, he added, does not resemble the home of the brave. Doe versus Reed is an important sign of big challenges ahead. The larger issue in Doe and Christian legal society, really the key one for us, was whether the Supreme Court would put its stamp of approval on the idea that gay people are a sinister mob that persecutes religious believers, who, by the way, should have permission to discriminate against gay people if they want to. This fight is not over. The fact that these cases are even at the Supreme Court demonstrates just how critical these times are, both legally and culturally. We have made gains, but there is enormous tension. Are these gay people really just people? Or are they different or dangerous or bad enough that they can, no, they must be treated differently from the rest of us? All these issues seem so double-edged. Can you acknowledge gay families in school, or does that mean talking about sex to second graders? Can gay people serve openly in the military, or will undermine the whole fighting enterprise? Can gay people marry without harming the institution for others and for children? We must meet these questions openly, honestly, fearlessly, and give people information and room to engage. Yet, we must also call out those who cynically construct a mythical and dangerous gay identity that others should fear. That fear, they hope, will distract the public, win them more ballot measures, win them court cases, and deny, or at least delay, the equality under law that we all deserve. So, despite the powerful and moneyed opposition we still face, we are all doing so many things right. Why else would we find that a majority of Americans, for the first time ever, now report that they do not object to, quote, the morality of gay-lesbian relations? What a question. The poll I'm referring to didn't make anyone's life better overnight, but it hints that a majority of people can now engage our issues on fairness terms and not just on anti-gay moral terms. We're also clearly at an extraordinary time in the federal courts, like no other, although we have plenty of challenges ahead. The DOMA cases, the Prop 8 case, the Don't Ask, Don't Tell case, are dramatic examples of federal judges ruling under the federal Constitution that the automatic, reflexive discrimination we've faced as LGBT people for so long, in fact, is unequal protection and not the way you treat your fellow Americans. So we all want to thank you for staying with us as we face these and other challenges. We must secure marriage in Rhode Island and Maine, end DOMA, make it possible to travel from state to state without losing our rights at the border. We must address the inequities and unique challenges facing our most vulnerable community members, including people of color, youth, those living with HIV, and our seniors. We must ensure that all families and all children are protected, marriage and regardless of marriage, that equality in jobs and schools and life opportunities will never suffer just because of who we are. In short, we need to keep it up. And GLAAD will be there for you. We will continue to be your strong, clear, and principled voice in court and wherever else law or policy is made. It's a long list. There is a lot of work to do, but we will never stop until it is done. Never. Thank you very much.